Supreme Court issued stunning 9-0 unanimous decision May 31st, 2026 that fundamentally protects gun rights for Americans aged 60 and older. Court held states cannot impose age-based restrictions on firearm ownership for seniors, cannot require competency tests or medical evaluations based solely on age, cannot force surrender of firearms when entering nursing homes or assisted living, cannot deny carry permits to seniors based on age-related assumptions, and cannot treat older gun owners differently than younger gun owners under Second Amendment or Equal Protection Clause. In landmark case Williams v. New Jersey, all 9 justices agreed age discrimination in firearm rights violates Constitution. Justice Barrett, writing for unanimous court, the right to keep and bear arms does not expire at age 65, 70, or any other arbitrary age threshold. Senior citizens are not second-class citizens when it comes to constitutional rights. States cannot presume incompetence based on age any more than they can presume dangerousness based on race. Subscribe because understanding this 9-0 decision protecting gun rights for seniors, which age-based restrictions are now unconstitutional, what states can no longer do to gun owners 60+, and how this affects nursing home residents determines whether you or elderly relatives maintain Second Amendment rights. Robert Williams, 72-year-old New Jersey resident, held carry permit for 30 years without violation. At age 72, state denied permit renewal requiring competency evaluation by state physician, cognitive testing, and family member attestation of mental capacity. State cited no specific concerns, denial based solely on reaching age 70 triggering mandatory review. District Court upheld. Third Circuit affirmed. Supreme Court reversed 9-0. Let me break down what court held, why all 9 justices agreed, which age-based restrictions are now unconstitutional, how this affects nursing homes and assisted living, and what gun owners 60+ must know. Number 1. What Supreme Court held unanimously. Core holding. States cannot impose restrictions on firearm ownership based solely on age. Cannot require competency tests, medical evaluations, or cognitive assessments based on age. Cannot presume incompetence or dangerousness based on age. Age-based restrictions violate Second Amendment, right doesn't diminish with age, and Equal Protection Clause. Age is suspect classification when fundamental right involved. Justice Barrett. Robert Williams is 72. He carried firearm lawfully 30 years, never convicted, never had accident, never threatened anyone. Yet New Jersey denied permit renewal solely because he turned 70. State applied blanket rule. Everyone over 70 must prove mental competence. This is age discrimination applied to fundamental right. Constitution does not permit it. Second Amendment protects the people, includes elderly. Nothing in text, history, or tradition suggests right expires at certain age. Founding-era Americans owned firearms into old age. No founding-era laws restricted based on age. Modern age-based restrictions lack historical pedigree. Under Bruin, they fail. Moreover, age discrimination violates equal protection. State cannot presume elderly incompetent any more than presume young reckless. If state has specific concern about individual capacity, regardless of age, state can address through existing mechanisms, mental health adjudication, guardian appointment, but cannot apply blanket age-based restrictions. Why unanimous? Conservative justices protecting Second Amendment. Liberal justices protecting seniors from age discrimination under equal protection. Elderly are protected class deserving heightened scrutiny. Roberts joining emphasizing rule of law prohibits age-based stereotypes. Scope. Applies to all age-based restrictions, mandatory competency tests at certain ages, required medical evaluations, cognitive testing, automatic permit denials, forced surrenders in nursing homes, family attestation requirements, shorter permit durations, higher fees. Number 2, unconstitutional restrictions in nursing homes, unconstitutional age-based restrictions, competency tests at certain ages, 65, 70, 75, medical evaluations for seniors, cognitive testing, memory tests, dementia screenings, automatic denials above certain age, nursing home/assisted living forced surrenders, family attestation for elderly, shorter permit durations for seniors, 1 year versus 5 year, higher fees for older applicants, nursing homes/assisted living. Facilities cannot require blanket surrender as condition of admission. Must conduct individualized assessments if concerned about specific resident. Must provide safe storage accommodations, safes in room, facility gun safe with access, family storage with resident ownership. States cannot mandate facility bans. Residents forced to surrender can sue under ADA, Age Discrimination Laws, Section 1983. What states can still do? Individualized basis. Mental health adjudications following due process. Notice, hearing, evidence, judicial determination, appeal. Applies regardless of age. Guardian/conservator appointments through individualized court proceedings, finding person lacks capacity. Address specific safety concerns through existing red flag procedures, emergency mental health holds, individualized interventions. Dementia/Alzheimer's diagnosis alone insufficient. Must show individual lacks capacity through proper proceedings. What triggers individualized assessment? Not automatic age-based. Specific reported incidents. Firearm accident, unsafe handling, threatening behavior. Credible family concerns with specific examples. Medical professionals' individualized recommendation, not blanket screening. Court finding of incapacity in other context. Age alone never sufficient trigger. Number 3. What gun owners 60+ must know and do. Know your rights. If you're 60+, states cannot. Require competency tests based on age. Demand medical evaluations because you're elderly. Deny permits solely because you reached certain age. Force shorter permit durations. Charge higher fees. Require family attestation. Presume incompetence. Same Second Amendment rights at 65, 70, 75, 80+ as at 30. Challenge age-based denials. If denied based on age or required age-based testing. Request written explanation specifying legal basis. File administrative appeal citing Williams versus New Jersey. Contact gun rights organizations, GOA, SAF, FPC, for legal assistance. File federal section 1983 lawsuit if denial continues. Williams establishes clearly established law, qualified immunity defeated. Nursing home/assisted living residents. If facility required surrender or denied admission because you own firearms, cite Williams to facility administrator, request individualized assessment if specific safety concerns, propose reasonable accommodations, safe storage, family retention, contact elder law attorney if facility refuses, file complaint with state ombudsman and adult protective services if retaliation. Protect against family interference. Under Williams, you have constitutional right to keep firearms unless individualized determination of incapacity. If family pressures surrender, consult elder law attorney about protective orders. Consider revocable gun trust with yourself as trustee. Document capacity through physician evaluation showing competence. Name trusted friend as backup. Estate planning. Create gun trust specifying who inherits firearms and when. Name successor trustee who shares your values. Document wishes about specific firearms to specific heirs. Ensure legal transfer to heirs. Comply with federal/state transfer laws. Verify heirs can legally possess, not prohibited persons. Document your capacity. If anticipating future challenges, obtain physician evaluation, documenting mental/physical capacity for firearm safety. Complete voluntary competency assessment showing you pass. Take certified firearm safety course, demonstrating safe handling. Maintain clean record, no accidents, violations, complaints. Update estate planning showing you manage affairs competently. Support legislative reform. Contact state legislators urging repeal of age-based restrictions, citing Williams versus New Jersey, requiring these repeals. Bottom line, Supreme Court unanimous 9-0 decision, Williams versus New Jersey. May 31st, 2026 protects gun rights for Americans 60+. Core holding. States cannot impose restrictions on firearm ownership based solely on age. Cannot require competency tests, medical evaluations, or cognitive assessments for seniors. Cannot presume incompetence based on age. Age-based restrictions violate Second Amendment, right doesn't expire at certain age, and Equal Protection Clause. Age discrimination against fundamental right. Why unanimous? Conservative justices protecting Second Amendment. Liberal justices protecting seniors from age discrimination. Complete agreement, age-based stereotypes unconstitutional. Unconstitutional restrictions. Competency tests at certain ages. Medical evaluations for seniors. Cognitive testing for elderly. Automatic denials above certain age. Nursing home/assisted living forced surrenders. Family attestation requirements. Shorter permit durations for elderly. Higher fees for older applicants. Nursing homes/assisted living cannot require blanket surrender, must conduct individualized assessments, must provide safe storage accommodations. State cannot mandate facility bans. Residents can sue under ADA, Age Discrimination Laws, Section 1983. What states can still do? Mental health adjudications with due process, guardian/conservator appointments through court proceedings, address specific safety concerns through individualized interventions. Dementia/Alzheimer's diagnosis alone insufficient, must show individual lacks capacity. Gun owners 60+. No rights, same Second Amendment rights at any age. Challenge age-based denials citing Williams. Nursing home residents cite Williams, request individualized assessment, protect against family pressure through estate planning, document capacity through physician evaluations, support legislative reform repealing age-based restrictions, subscribe because this 9-0 decision protecting gun rights for seniors changes what states can do to gun owners 60+, and understanding your rights determines whether you maintain Second Amendment protections. Supreme Court 9-0. Gun rights don't expire with age. Seniors have same Second Amendment protections as younger gun owners.